this topic is very important and near to my heart. We're going to talk now about the act of declaring war and the war powers, because I think that's important. And I think that we should break it down and take a look at what exactly we're talking about when we speak about the war powers in the US context. So let's first read this article, also from Russia and Global Affairs, called L'État c'est lui. And this is from Dylan Payne Royce, who's now a research fellow in Russia, but was educated in the US. So we have here the article talking about war. He writes, due to a misunderstanding of the US legal system, under which the Constitution is supreme, right? It's the supreme law of the land, and a misreading of certain laws, some confusion has arisen within the Russian expert community regarding the legality under US law of Trump's attack on Iran. I would like to take the opportunity to clarify that the attack is manifestly illegal. The US Constitution, which in theory still matters and indeed takes precedent over all other law in the US, provides Congress with the authority to declare war. It does not provide the president with similar authority. Accordingly, the US may conduct hostilities or at least initiate war against another state only with congressional authorization. Obviously, going to war with another state without actually declaring war does not allow the president to avert this clause. It merely means that the action is now not only unconstitutional, but also a violation of international custom norms. One of several such violations, given he means Khamenei's assassination, a violation of the norm against targeting leaders, the murder of Iranian schoolgirls and other civilians, who amongst Iranian casualties so far appear to outnumber legitimate military targets, incidentally, in the same way that civilians have been the vast majority of Israeli victims in Gaza. Note the specification above: 1, initiation; 2, of war; 3, against another state. That is definitely the authority of Congress. Gray areas do exist around 1, waging a war that has been started by an adversary; 2, deploying forces into a context and or for purposes that may develop into combat; and 3, using force against non-state actors. The War Powers Resolution was intended to address these and perhaps other gray areas. It constrained the president's authority within such situations and certainly did not expand his authority beyond such contexts. In particular, the War Power Resolution requires that if the president deploys forces for combat or potential combat in a manner that is permissible under the Constitution, example, in response to attack or for combat adjacent purposes, for example, advisors to South Vietnam or forces in Saudi Arabia to deter a continued Iraqi offensive in 1990, or against a non-state actor like Al-Qaeda, then the president must receive authorization from Congress within 90 days. Again, this is not an expansion of the president's authority, but a narrowing of it. It was intended to prevent a repeat of the U.S.'s slide into the Vietnam War. It does nothing and could do nothing, given constitutional supremacy, to alter Congress's exclusive authority to initiate war against other states. The resolution explicitly states this in its 3rd paragraph. The constitutional powers of the president to introduce U.S. forces into hostilities or into situations where hostilities are likely are exercised only pursuant to 1, a declaration of war; 2, specific statutory authorization; or 3, attack upon the United States, its territories or possessions, or its armed forces. He has none of these things. The attacks, therefore, are unconstitutional and illegal under U.S. law. If the rule of law still existed within the U.S., the U.S. military would have refused to obey the orders, given that they are illegal and thus invalid, and the president would be impeached for high crimes and misdemeanors. Actually, he really should have been impeached during his first term for the almost as clearly illegal airstrikes against Syria. Unfortunately, such strikes were one of Trump's few actions that Democrats actually supported. Democrats were, if anything, mostly concerned that Trump was not hawkish enough in his first term, inventing the Russiagate hoax and impeaching Trump for the high crime of not supporting Kiev with sufficient enthusiasm. And indeed, Obama also violated the Constitution with his attacks on Libya, although they, like Trump's airstrikes on Syria, were not quite as blatantly illegal as Trump's attack on Iran and Venezuela, since Libya and Syria were riven by civil wars and thus conceivably their governments could be viewed as illegitimate. So these new attacks are probably best seen less as specifically Trumpian or Republican failure and more as a manifestation of the US's general slide from the rule of law into Caesarism, not the fun kind. So This is a great perspective from a scholar in Russia, U.S. trained scholar in Russia, who's speaking about this. Now, what I want to do is I want to go in for you all so you can look and analyze this on your own if you have time at some point. I want you to be able to use these resources and to learn how to do that. So let's go to let's go here to read the Constitution and some thoughts. So for those who don't know, I studied law at Cornell Law School, and this is the Cornell Law School Legal Information Institute. It's one of the best resources if you're interested in the law. I don't know if we have any lawyers in the chat. Those of you who have studied the law, either as a JD, as an LLM, as an MSLS, as a master's in law, as a bachelor's in law, whether it be an LLB or something, all of you understand that the law is very important and critical to understanding the structure of power, the division of power, and how that power is used. Now, here we have the U.S. Constitution annotated, and I'll show you how to look at it. So we already know, everybody here knows that the war powers are vested in the legislator. So we're looking at Article 1 of the Constitution. So the Constitution has how many? It has 7 articles, and then it has amendments. So we're looking at the articles, not the amendments. The first 10 amendments of the Constitution are called what? Do we have anybody in the chat who knows what the first 10 amendments to the U.S. Constitution are called? They have a special name for those who know. I'm curious if we have anybody in the chat who can throw it up there. There we go, the Bill of Rights. The Bill of Rights. And that was a very important part of the big constitutional debate that took place after the Articles of Confederation began to unravel. And you had the big debates between Federalists and Anti-Federalists, and the big constitutional debate between the states. And eventually you have the Bill of Rights that are added to the Constitution. But you have the first 7 articles. So let's go to Article 1, the legislative branch. And let's go to, we are looking for here, hold on. We are looking for war powers. So let's look here. Oh, actually, I want to go here. It doesn't, actually, there's a mistake here. So I'm going to have to, hold on. Let me go back here. Put 1 here. There we go. War powers, Clause 11. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, right? So the legislator is the sole power in the United States that can declare war, at least according to our legal architecture, according to our structure of government. Of course, many of us know that a lot of this doesn't really hold weight and nobody's held accountable, but at least I want to show you what on paper it looks like. By the way, somebody's saying that I would make a great teacher. I've been a teacher for 8 years. I was a professor, a lecturer, and a high school history teacher. So this is what I do. This is, I've taught US history, world history, all of that stuff. So I'm already there with you all. So let's keep going here. So now what we want to do, let's look at the source of war powers, because I think that's interesting for us to understand why is the legislator the one that has the war powers and not the president, for example. So we click here, source of war powers, Article 1, Section 8, Clause 11, source of war powers. The Congress shall have power to declare war, like we said. Now here's the notes on this. 3 different views regarding the source of war powers were expressed in the early years of the Constitution and continued to vie for supremacy for nearly a century and a half. In The Federalist, Alexander Hamilton elaborated on the theory that the war power is an aggregate of the particular powers granted to a national government. In 1795, the argument was advanced that the national government's war power is an attribute of sovereignty and hence not dependent upon the affirmative grants of the written Constitution. In McCulloch v. Maryland, Chief Justice Marshall appears to have taken a still different view, namely that the power to wage war is implied from the power to declare it. During the Civil War era, the two latter theories emerged from the Supreme Court. Speaking for 4 justices in Ex parte Milligan, Chief Justice Chase described the power to declare war as necessarily extending to all legislation essential to the prosecution of war with vigor and success, except such as interferes with the command of the forces and conduct of campaigns. In another case, adopting the terminology used by President Lincoln in his message to Congress on July 4, 1861, the court referred to the war power as a single unified power. In 1936, the court explained the logical basis for imputing such an inherent power to the federal government. In United States v. Curtis Wright Corp., Justice Sutherland stated the reasons for this conclusion. As a result of the separation from Great Britain by the colonies acting as a unit, the powers of external sovereignty passed from the crown not to the colonies severely, but to the colonies in their collective and corporate capacity as the United States of America. Even before the declaration, the colonies were a unit in foreign affairs, acting through a common agency, namely the Continental Congress, composed of delegates from the 13 colonies. That agency exercised the powers of war and peace, raised an army, created a navy, and finally adopted the Declaration of Independence. It results that the investment of the federal government with the powers of external sovereignty did not depend upon the affirmative grants of the Constitution. The powers to declare and wage war, to conclude peace, to make treaties, to maintain diplomatic relations with other sovereignties, if they had never been mentioned in the Constitution, would have vested in the federal government as necessary concomitants of nationality. That's brilliant legal speak. But this provides you with an opportunity to take a look at not only the War Powers Act, or the War Powers in the clause in the Constitution, and later on the various actions that take place and different legal bills that are passed, including the War Powers Act, but also the origin of why we have this power vested in the legislator. And of course, at the end, we understand that because we divided from Great Britain, because we had a revolution, and that revolution was comprised not by one, but of all of the colonies together in unity, that power then is vested in the federal government and specifically in the legislator. And that is the source. That is the source of where sovereignty resides, because the people are sovereign. We do not have a monarchy in the U.S. We don't have, a hereditary monarchical rule like an aristocracy, and landed aristocracy like in the United Kingdom, which we had a revolution against. But that sovereignty rested in the people. Therefore, the people's representative, the representatives of the people, have the power vested in them by the mere fact that they are representatives of the whole of the people. And so, in this republic way of thinking, that's why the legislator is enshrined with this right for declaring war. So that's very important for people to understand.